Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we close the loop on Hunter v. United States. On Thursday, June 18th, the court just rewrote the rules on appeal waivers nationwide.
The justices ruled 8-1. Justice Kagan writes for the majority. The headline, an appeal waiver no longer locks the door shut completely. If enforcing it would create what the court calls a miscarriage of justice, an appeals court can crack that door back open. But the Raw split tells only half the story. Gorsuch, Kavanaugh, and Barrett each file separate concurrences. Justice Thomas dissents alone. This case touches nearly every federal defendant out there. Roughly 95% of federal cases end in plea deals, and most of those deals carry an appeal waiver.
As you may recall from our episode preview, we framed this whole case around my parents' Florida timeshare. The timeshare pitch sounds amazing, but they always seem to gloss over the crushing fees. Munson Hunter's story runs the same way, except instead of timeshare fees, he ends up staring down forced medication.
Before going further, here's your reminder to follow. Rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. Picture the scene. Federal prosecutors in the Southern District of Texas hit Munson Hunter III with a 10-count indictment, bank fraud, wire fraud, the works. A scheme draining roughly $500,000 from financial institutions over years. On paper, Hunter faces up to 300 years behind bars and a $10 million fine.
300 years. The United States itself doesn't even reach back that far. America, 250.
Right? So that exposure pushes Hunter straight into a plea deal. He pleads guilty to just one count, aiding and abetting wire fraud, tied to a single transaction worth $38,648.77. The government drops the other 9 counts in exchange.
Standard plea deal stuff so far.
Totally standard until you hit the fine print. Hunter signs an appeal waiver. He gives up his right to challenge his conviction and sentence completely, with one carve-out: ineffective assistance of counsel claims. The judge reads that waiver out loud and tells Hunter, quote, "Basically, you're agreeing to whatever sentence I impose." Hunter says yes.
And here's where it gets interesting.
At sentencing, the court doesn't calculate Hunter's guideline range off the $38,000 he actually admits to. It uses $488,352.25 instead, spread across 26 transactions, some from dropped charges, some never charged at all. That swap pushes his range from 15 to 21 months up to 41 to 51 months. The judge picks the very top, 51 months in prison plus 3 years of supervised release. Then things went wrong.
Then things go properly sideways. One release condition requires Hunter to take, quote, all mental health medications a doctor later prescribes. Hunter objects on the record. He says he doesn't want to be forced to medicate. The judge tells him he should take whatever gets prescribed, but says he can raise future disputes with probation first, and the court if needed.
Okay, but where's the actual legal landmine?
Right here. Closing out the hearing, the judge turns to Hunter and says, quote, all right, you have a right to appeal. Hunter's own lawyer stays quiet. The prosecutor starts to object, then stops mid-sentence. Quote, Your Honor, I believe I will know.
So the judge just hands Hunter the opposite of what the signed deal says, and the government just lets it happen?
That's the whole ballgame right there. So how does this climb all the way to the Supreme Court? Well, Hunter appeals to the Fifth Circuit, challenging just the medication condition. The government moves to dismiss based on the waiver, and in December 2024, the Fifth Circuit agrees, dismisses the appeal outright. Their rule allows only 2 exceptions: ineffective assistance of counsel or a sentence above the statutory maximum. Neither fits Hunter, so the door slams shut. But other circuits don't see it that way.
And that split grabs the Supreme Court's attention. Most circuits already recognize a broader miscarriage-of-justice safety valve. The Fifth Circuit and a handful of others stick to that rigid 2-exception list. The court grants cert to settle, which approach wins nationwide, hears oral argument March 3, 2026, and rules June 18th.
Okay, so here's the simple version of what the court grapples with. Does an appeal waiver always control, no matter the sentence? Or does some limit exist beyond the Fifth Circuit's 2 narrow exceptions? Put another way, Can the government hold you to a deal you signed before you knew your sentence, even if that sentence later turns out unconstitutional or just plain bizarre? And Hunter's lawyer leans hard into contract law to answer that.
She does. Hunter's attorney, Lisa Blatt, builds her whole opening around contract defenses: frustration of purpose, unconscionability, the works. But Justice Barrett pushes back almost immediately at oral argument, saying the exceptions Blatt wants don't really fall within contract defenses, and that it feels like the court would shoehorn them in.
So even at argument, the contract theory starts cracking?
It cracks hard. And it matters, because the final opinion never even mentions contract law. Kagan builds an entirely different foundation instead.
Help me picture this. What does signing an appeal waiver actually feel like?
Picture handing someone a blank check. You trust they'll fill in a reasonable number. Most of the time, they do, but nothing stops them from writing in something wild. Not a perfect comparison, since a judge isn't literally writing dollar amounts, but the trust and hope structure tracks. So if contract law doesn't win the day, where does the majority actually land?
Step 1. The court tosses Hunter's easiest argument out the gate. Hunter says the judge's "you have a right to appeal" comment, plus the prosecutor's silence, kills the waiver. Kagan says no. The agreement requires written, signed changes for any modification, and silence never counts as giving up a right. The government's real chance to enforce the waiver comes after Hunter actually files his appeal, not at sentencing. Kagan even cites Class v. United States, a 2018 case where a defendant's silent acceptance of a judge's mistaken statement carried zero legal weight either way. She calls it a near mirror image.
Okay, that clears the small stuff. What about the real question?
Here's where it gets interesting. 3 rules sit on the table. The government says a knowing voluntary waiver always controls, period. The Fifth Circuit says only 2 exceptions ever apply. Most other circuits already split the difference with a miscarriage-of-justice standard. Kagan's answer comes down to something simple. Courts stay deeply involved in approving these deals. A district judge must sign off under what the court calls sound judicial discretion, citing Santabello v. New York, a 1971 case putting plea deals under judicial control, not just prosecutorial control. A court of appeals then holds total power over whether the waiver sticks at all.
So courts can't just wash their hands of it. Same logic shows up in United States versus Mezzanotto, a 1995 case. And here's where things get fun, because Mezzanotto holds the most famous line in the whole opinion.
Please tell me this involves the orangutans.
It 100% involves the orangutans. Mezzanotto quotes an old ruling. Even if everyone agreed to a trial by 12 orangutans, the conviction still wouldn't count. Some baseline of fair procedure survives no matter what anyone signs. At oral argument, Justice Gorsuch runs straight at this with government lawyer Zoe Jacoby. If a judge let an orangutan pick a defendant's sentence out of a hat, would the waiver still block an appeal? Jacoby tries to hold the line. That bargain only hands the district judge final say, and judges stay oath-bound, regardless. The argument doesn't really land. Kagan takes that exact example and writes it straight into the majority opinion.
Okay, that's wild. But how does that turn into an actual legal rule?
Both extreme positions collapse. The government's all waivers always bind rule slams into a wall even the Fifth Circuit won't accept. A sentence that blows past what the statute allows. And that same logic breaks the Fifth Circuit's narrow rule, too. Race-based sentencing, a pregnancy ban as a release condition, sentencing by orangutan. None of those fit inside the Fifth Circuit's tiny exception list either.
So basically every option on the table breaks somewhere?
Pretty much. So Kagan adopts the miscarriage-of-justice standard most circuits already use, but sets a genuinely high bar. The error must count as obvious, not something a reasonable judge could plausibly get wrong, and it must threaten public confidence in the judiciary itself. Ordinary sentencing mistakes don't clear that bar.
And here's where oral argument basically previews the final opinion word for word. The government offered a fallback at argument, 3 categories: race-based sentencing, a categorically unlawful sentence or condition, and a sentence reached without a minimum of civilized procedure. Kagan pushes back from the bench. Why not just say miscarriage of justice and trust lower courts with that high bar instead of locking in rigid boxes? So oral argument basically becomes a live draft of the holding. In the actual opinion months later, Kagan does both. She announces the open-ended standard, then offers those same 3 categories as non-exclusive examples.
Pretty much exactly. 8 justices sign on to this. An appeal waiver stops controlling a defendant the moment enforcing it would create a miscarriage of justice. An obvious egregious error serious enough to embarrass the judicial system itself. Kagan writes for the majority.
And since the Fifth Circuit never asked that question under the new standard, the court vacates the ruling and sends Hunter's case right back down to answer it fresh. So Hunter doesn't win outright. He just wins the right to argue his case under the real standard.
Exactly that. 3 concurrences pile on, plus Thomas's dissent. Start with Gorsuch, joined by Sotomayor and Jackson. He agrees with the result completely, but writes separately to trace how plea bargaining grew from something courts once distrusted into the machine running 95% of federal convictions today.
Does he push the standard further than the majority?
He tries to. Gorsuch lists a much fuller catalog of what should count as a miscarriage of justice, including plain errors in calculating a defendant's sentencing guideline range, and goes further still, openly wondering whether appeal waivers signed before a defendant even knows his sentence can ever truly count as knowing and voluntary at all.
That sounds like a bigger swing than what the majority actually holds.
It counts as a bigger swing, and Kavanaugh notices immediately. Kavanaugh, joined by Alito and Barrett, joins the majority in full, but writes separately purely to push back on Gorsuch, saying flat out that Gorsuch's reading sets a lower bar than the majority opinion does, and reminding everyone the majority controls, not the concurrence.
So Kavanaugh basically guards the fence around the new exception before anyone tries to climb over it.
That's a great way to put it. Barrett writes solo, tackling a quieter question. Where does this new rule come from? She doubts the court taps any real supervisory power over lower courts. Instead, she roots the decision in old-school, procedural common law, settled doctrines built up over time, not something the court just invents on the spot.
And then Thomas dissents alone, swinging hard. His core argument, the majority can't point to any real source of law for this rule, not a statute, not the Constitution, not a federal rule, not even an established common law doctrine. He thinks the majority quietly leans on supervisory power without ever naming it. And that links right back to oral argument, where Justice Kavanaugh presses government lawyer Zoe Jacoby on exactly this question. Jacoby admits the doctrine could come from federal common law, supervisory power, or the statute itself, but concedes courts everywhere already apply some version of it without ever fully explaining why.
And Thomas worries. This floods the courts?
Hard. Roughly 65% of federal plea deals carry an appeal waiver. He warns this opens the door to a serious wave of new appeals.
Time for what this actually means. Our segment translating the legalese into your actual life.
So what actually changes?
For the 95% of federal defendants who take plea deals, an appeal waiver no longer guarantees a dead end. If a sentence crosses into truly egregious territory, race-based factors, an unconstitutional condition, zero real procedure, defendants now carry a real shot at appellate review nationwide, not just in the handful of circuits that already allowed it. That ripples out to defense attorneys negotiating plea deals, judges drafting sentencing conditions, and prosecutors too, who now need to think twice before tacking on an unusual condition. It plays a lot like a warranty that voids itself the second you try to use it, except the stakes run a whole lot higher than a busted dishwasher.
But doesn't the government's floodgates worry hold any water?
The court doesn't think so. An oral argument actually backs that up. Hunter's lawyer pushes back hard on exactly this concern, telling the justices, quote, "There's no flood, there's no appeals. There's 30 years of this. Circuits already running this standard for decades haven't drowned in litigation, because a genuinely high bar filters out weak claims fast."
Thomas disagrees hard, though. He runs the numbers. 65% of plea deals carry waivers, over 680,000 guilty pleas across the last decade. He warns of a real wave of new filings testing the standard's outer edge.
So what's the open question going forward?
2 big ones. First, does Hunter's own forced medication condition actually clear this new bar? That question goes back down to the Fifth Circuit to decide fresh. Second, and bigger, Gorsuch's concurrence plants a seed asking whether appeal waivers signed before anyone knows their sentence can satisfy the Constitution's knowing and voluntary requirement at all. The majority doesn't touch that question this round, but somebody's going to bring it back.
Bottom line?
Appeal waivers stop meaning absolute, ironclad surrender. Courts now keep a genuine emergency exit, even if the court keeps that exit narrow and hard to find.
And for the 95% of you out there who will probably face a plea deal someday, Read every line, because apparently even the judge can misspeak about your rights on the record. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And remember, folks, unlike Hunter's plea deal, subscribing to this podcast comes with 0 fine print and 0 forced medication. Talk to you soon.